The matter before the court this afternoon is the case entitled In Re GL, case number 24AP012. Representing the appellant Mother NP is attorney Carrie Johnson. Representing the appellee Department for Children and Families is attorney Zachary Martin.
Thank you, Mr. Bailiff. Good afternoon, counsel. We'll hear from counsel for the appellant first, of course. Please introduce yourself, identify your client, and then proceed.
Thank you. Good afternoon, Your Honors. May it please the court. My name is Carrie Johnson, and I represent the appellant Mother NP. When we remove a child, especially a baby, from her parents and place her in a foster home, we expect that foster home to be safe. We expect it to be a better environment than the one the child was taken from. The only reason it is acceptable for the government to take children away from their parents and permanently sever the legal relationship between parent and child is to protect the child from real danger and to create safety and permanency in a new adoptive family. DCF's conduct in this case infected the integrity of the entire proceeding, beginning with the termination of parental rights and extending through the appeal and persisting throughout the Rule 60B proceeding. Termination of parental rights has been nicknamed the civil death penalty because it is the most serious consequence of any civil proceeding. The permanent destruction of a child's natural family. TPR was granted in this case with the express understanding that the child, who was at the center of the case, GL, would be adopted by her current foster parents. The fraud that occurred in this case,
don't we have case law that essentially says that whether a child is to be in a certain adoptive home or with certain foster parents isn't a factor that the court considers or that we consider in looking at a TPR?
I believe there is case law to that effect, Your Honor. However, the only compelling reason for terminating parental rights is either because the parent poses such a threat to the child that even the fact that they're retaining their parental rights is harmful, which was not the case here, or it's to facilitate an adoption. It's really not ever in a child's best interest to create a legal orphan, which is what occurred in this case. And I think most courts weigh, whether there really is timely permanency on the horizon or not when deciding whether to grant a TPR or even let a TPR trial go forward. They may say, the judge may say it's not ripe yet because the child doesn't even have any kind of permanency identified.
Ms. Johnson, can I?
Where that we routinely affirm TPRs that were granted where there was no foster placement that was identified.
Yes, Your Honor, and I really think that we should question that practice because what it's doing is it's a loss for the child and there's no gain if that child doesn't get permanency. There really isn't. The only legitimate government purpose to terminating parental rights is either to protect the child or to facilitate an adoption. If it's not doing either of those things, then I think there's a very good constitutional argument that it's not constitutional to terminate parental rights because it's not justified.
Can I ask you one more question and then I'll stop? You said in your brief that DCF during one of its meetings talked about keeping from the court and the attorneys whether the foster family had these issues. I looked at the page you cited and I didn't see anything that hinted to them talking about keeping something intentionally from the court. Are you sure that's what they said?
I am sure, Your Honor. There is a note from July 19th, where DCF met, and they said that they wanted to know, that the court was going to want to know why the adoption was being held up, and they discussed what to tell the court, and they decided that they couldn't tell the court or the child's attorney
because of the confidentiality of the records.
That was, I don't recall if that was the justification, if that was documented in that same note from July 19th. But that was a week before this court of the decision affirming the TPR became final. When that conversation occurred, DCF did provide that justification after the fact, at least, that they believe they couldn't because of confidentiality. The fraud that occurred in this case worked the worst damage to the child. She thought she was being TPR'd so she could be adopted. And then she wasn't adopted because of significant, long-standing substance use disorder that persisted in this foster home despite years of medication-assisted treatment and chronic.
Have we?
Yeah, I
Lost
can't
the
hear her, Your
audio.
Honor. Chief, I can't hear her.
Attorney, counsel, we cannot hear you.
Can you hear me?
That's
we-
better. Yeah, that's okay.
Okay, I'll try to speak up. I think that any judge would want to know that at least one of the pre-adoptive parents had a drug problem that and had been unable to maintain sobriety despite being in medication-assisted treatment over a period of years. I think any judge would want to know that one of the witnesses had a documented history of dishonesty with DCF.
Right, and assuming those things to be true, how do either of those things make your client a more suitable parent?
We weren't, Your Honor, allowed to present that evidence. We tried. Mother came in prepared to present testimony about how it was in GL's best interest to maintain a relationship with her mother. Mother was prepared to present evidence showing where she was at in her life and that she had capacity to be a safe parent, and the court wouldn't allow us to present that case.
What I'm a little confused about, though, is the discussion here about the court would want to know about this foster family, the use of drugs, the untrustworthiness. Yet in these proceedings, your client and all the other parties agreed after all this to have the child fall under a permanent guardianship with these people. So is it harmless or isn't it?
We went into the proceeding stating that we would support that as long as my client could have some rights to visit with her daughter. However, as the discovery came out, we asked the court for an opportunity to really test whether this was a safe home. And again, the court denied Mother the opportunity to ask probing questions about exactly what was being done to monitor the foster father's sobriety, including his alcoholism, which he had a very long history of alcoholism and was drinking at least over the summer of 2022. And we don't know if he stopped drinking, and we weren't allowed to ask DCF what they were doing to monitor that. It's an enormous decision that a court has to make, whether to terminate parental rights. It's critically important for children and families to get it right. It's a grave, grave decision, and we have designed this system in order to give the court as much information as possible. When the actor is a government agency, if you narrow the availability of relief under Rule 60B so much so as to require intentional conduct on the part of each and every individual involved, That runs contrary to both the plain language of the rule and would also serve to greenlight the type of problematic conduct that occurred in this case. The plain text of Rule 60B states that it was intended to replace the writ of coram nobis. The writ of coram nobis was applied to call the court's attention to facts that would have changed the court's findings, but were outside of the record and unknown to the court at the time of judgment. The information that DCF had about these foster parents at the time of TPR would have definitely changed the court's findings had it been known. Rule 60B is a remedial statute, and remedial statutes must be liberally construed.
We've lost you again, Attorney Johnson.
I'm sorry, can you hear me now?
Still not, at
No.
least for me.
Okay, I'm not sure
No,
what's happening.
no. Maybe you should turn your video off.
I can do that. Can you hear me any better now?
No, I guess that's not going to work either.
Oh.
No.
I'll tell you what, we could, how much time does the appellant have, please? How much time does she have
At
left?
this moment, appellant has 5 minutes and 9 seconds remaining. I can hear appellant for what it's worth, Chief.
I can
I
too,
can
Chief.
too.
What's
I
that?
can-
I can hear her.
Oh, you can. Okay, I'm sorry.
We can, Chief.
All right, I think
I think
I
it's
must
just you, Chief.
yeah, I apologize. Okay, go ahead, counsel.
Thank you. Rule 60 has to be read broadly enough to avoid absurd results. And it would be an absurd result to find that there's no remedy when a party and a party's attorney concealed this much information from the court and the other parties to the case. It's impossible to prove the mens rea of an organization, and requiring us to do so would essentially excuse all organizations from a finding of fraud upon the court. If the
But
organization
isn't intent, Ms. Johnson, isn't intent though a element of fraud? So I'm having trouble understanding your argument if you're asking this court to set aside what might be intent when it's an essential element of fraud.
Well, a mens rea of recklessness is sufficient, and that's what we argued below, is that DCF has created a system where they're segregating foster parent information. We have in statute a definition of in court rule, a definition of what the file is. And Attorney Gross in this case asked for the file. DCF's defense here is that the file didn't mean the whole file. But under VRFP 2D6, the file means anything within the possession, custody, or control of DCF that relates to the child, the parents, or the subject matter of the proceedings. The information that was concealed here was definitely relevant to the child, GL, and it was relevant to the subject matter of the proceedings. And as I raised below, that rule also places an affirmative burden on DCF to move for a protective order if it wants to hold something back. In this case, DCF held back all of the negative information about the foster parents and the foster home in the foster care file by labeling that as not discoverable. And they know that they do this as a matter of course. They know that social workers don't, the DCF worker who is monitoring the safety of the child in that home, as this DCF worker testified, don't go and check that file. So they're not aware of the history. They can't testify to it at the TPR. The only person who could conceivably testify to their history is the foster parent. And if that information isn't disclosed, there's the attorneys can't be assured that they're getting the truth out of the foster parent. You can't simply ask and expect someone's going to tell you, especially if they know that you can't ever get those records. So DCF and its lawyers do know that the practice here means that none of the witnesses, other than perhaps the foster parent, know anything about the current risks in the foster home or their problematic history or any other event that might tip the balance against TPR. And once DCF learned that there was a current active substance use problem in this foster home, and that the foster parents were continuing this pattern of dishonesty that continued all along, they didn't tell the court, they didn't tell this court, even though the appeal was still pending, they didn't tell the trial court. Instead, they had a meeting where they talked about how the court was going to want to know, and they weren't going to, they're not going to provide that information. Indeed, they did not provide that information for, that meeting was July 19th. They didn't provide the information until a permanency case plan that was filed at the beginning of September.
You have 1 minute, counsel.
Okay, thank you. So this court affirmed the TPR based on testimony of a witness who was not credible, based on representations about the safety and suitability of a foster home that was not safe, it was not suitable, and it was not even pre-adoptive.
What witness was it that was not credible?
The foster mother, that was, she was a key witness against NP at the TPR hearing. She testified extensively about the quality of her home, the quality of both her relationship and her husband's relationship with GL. And she put out quite a bit of negative information about her observations of my client's behavior in meetings, times that she had gone to my client's home to pick up the child, etc. I think the fraud in this case is really obvious when you look at what the agency knew and when it knew it.
Okay, I think your time has expired. Thank you very much. We'll hear from counsel for the appellee now. Please introduce yourself and identify your client, then go ahead.
Thank you. Good afternoon, Your Honors. My name is Zach Martin, and I represent the Vermont Department for Children and Families in this case. So I want to start by saying that I don't think anyone, including me, is saying that the non-disclosure that occurred in this case was a good thing. But the issue that this court has to decide is whether the trial court abused its discretion in finding that it wasn't fraud on the court. That's the narrow and specific issue that's before this court today. And the court was very solicitous of mother's claims. It afforded her ample hearing time, first just to articulate her theory of relief, about 3 hearing dates, and then I believe another 5 hearing dates to prove her claim with evidence, with clear and convincing evidence. And mother did not carry her burden, and the trial court, after making extensive credibility findings, including findings that Attorney Woolard's testimony about how the various DCF records are stored, correctly exercises discretion, and this court should affirm that determination. I welcome the court's questions, but I do want to touch briefly on just a couple things that were raised in the reply brief, if I may. One thing relates to the arguments raised on pages 9 through 12 of the reply as to the motion to reopen. And I guess what I would say is—
Stop you. I'm sorry,
Certainly.
can I stop you for a second? Because I don't see my colleagues on here anymore. And
No, it looks like the videos have cut out for a number of people,
Okay.
Justice Carroll. So
can everyone
uh,
still hear though?
Yes, I can. Thank you, Justice
Yes, I
Carroll.
can
Thank
hear
you,
and I
Chief.
can see.
Okay, thank you.
all right, please go ahead then.
Okay, thanks. Please feel free to let us know if something else happens or if we need to take a break and fix it. So as to the motion to reopen arguments raised in mother's reply brief on pages 9 through 12, what I would say to that is that the trial court wasn't required to view the allegations in the motion to reopen or the affidavit in the way or through the lens that appellant mother wished it to. The trial court was not required to pile inference upon inference. It had to assess the plausibility of those claims, and it did. It made a credibility finding about that, essentially. And I think if you look at the trial court's order on the motion to reopen, which is at pages 71 through 72 of mother's printed case, it comes through what its view of those claims are or were. I also want to respond to a case cited on page 9 of the reply brief. It's a Colorado Court of Appeals case, People ex rel SG. Appellant cites that case for the proposition that fraud in the court was not found where the department timely disclosed the presentation of erroneous evidence to the trial court and the parties following a termination of parental rights. I guess I just want to clarify what SG actually held, which is that it wasn't that there was no fraud because the department disclosed the presentation of erroneous evidence in a timely fashion. Rather, no fraud on the court was found in SG because the trial court found the department's attorneys in that case were not aware at the time of the TPR trial of the inaccuracy of their witnesses' testimony. So if you read SG, its holding in this regard, to the extent it's persuasive, supports affirmance of the trial court's decision in this case, because the trial attorney for the department here had no knowledge that there were these other elements to the foster family at the time that the testimony was presented. So I guess I want to respond to the footnote on page 7 of the reply brief, which suggests a rule of automatic disclosure of the foster care licensing file in every termination of parental rights or Chin's case. And I would ask the court, understanding the concerns here and the way that these files are stored and the confidentiality protections around them contributed to the issues in this situation, I would ask the court to exercise caution because there is a reason why those foster care licensing files have that additional confidentiality protection. And I guess I would respectfully submit that either legislative action or perhaps a referral to the Advisory Committee on Family Rules or for family proceedings would be a more precise way to address that, given the delicate balancing of interests there. And the fact that many people probably wouldn't sign up to be foster parents and take children into their homes if they knew that all of their information would automatically go to respondent parents in Chin's and TPR cases. I think it would probably disincentivize that quite a bit. I'm not saying parents can never get it. I'm sure that this case, regardless of what this court decides, will result in quite a bit of additional scrutiny towards foster parents and their records, probably more specific discovery requests, perhaps litigation around that. But I don't think it should be automatic in every case. It's what I'm trying to say. So I appreciate the time. I welcome the court's questions, if any.
Okay. All right, counsel, I don't see any hands, so thank you very much. Does the appellant have any time?
Appellant has no time remaining.
Okay, please call a conclusion.